Right, so let's move on to the more complex part of the McNaughton rules, which is disease of the mind. And the first thing to say is that to grasp the understanding and the context, that this is a legal, not a medical definition. And what that does, and it causes a lot of students problems because it allows lots of diseases, lots of illnesses that we wouldn't normally associate with insanity. And it's very easy to get lost in the idea of not understanding that this is a legal, not a medical condition. The second thing to say is that it must be a physical disease. That's not one caused by external factors such as drugs. It's got to be a physical disease, and it can be either permanent or it can be temporary. Okay. So let's have a look at what the disease of the mind is. And the easiest way to do this is to look at some of the perhaps more strange instances of diseases that are included in this legal definition. And the first one is one called arteriosclerosis, which I hope I've spelled right. Arteriosclerosis. That's a dot because that's an I. And in this case, in R.V. Kemp, 1957, the defendant is an elderly man who suffers with arteriosclerosis, which affects the flow of blood to the brain. This sometimes caused him temporary unconsciousness, and during one episode of this, he attacked his wife with a hammer and killed her. The court decided that this was a case of insanity rather than automatism, and more important, established the fact that a disease of the mind could be temporary. So here we're going temporary. This is an issue of temporariness. And the actual medication of the brain was not in itself relevant. Judge Devlin stated, "In my judgment, the condition of the brain is irrelevant, and so is the question whether the condition of the mind is culpable or inculpable, transitory or permanent." And so Kemp was found guilty but insane, which is the old verdict, the old special verdict. Now, of course, it would be not guilty by reason of insanity. But in 1957, before the changes in the law, it was guilty but insane. And Kemp was used when the court considered the decision in Bratty versus Attorney General for Northern Ireland. And in that case, we're talking about an issue of epilepsy. The defendant suffered a psychomotor epileptic seizure during which he strangled his girlfriend. This illness means that it's possible to carry out purposeful acts whilst in an unconscious state. The defendant was driving his van with his girlfriend in the passenger seat. He removed her tights and strangled her with them. Now, I'm not so sure whether he was driving at the time, but it seems unlikely. Approving the statement set out in Kemp, so they've taken the decision in Kemp, Lord Dennin adds to that to say that any mental disorder which was demonstrated by violence that was prone to occur was a disease of the mind. Now, this should be seen as an additional pointer rather than a limiting factor on what amounts to a disease of the mind. Dennin was anxious to protect the public from people who suffered in this way. The court said this type of seizure could amount to insanity and gave the court the opportunity to distinguish insanity from automatism. As it was in Bratty, he was found guilty. But we can already see that arteriosclerosis and epilepsy are included in defences of insanity. Now, that's because it's a legal definition, not a medical one. But what Dennin's judgment does is it means that lots more cases, lots more diseases can be included. One, for instance, would mean that sleepwalking now, because of what Dennin has said, is included. And the case for that, if you want to look it up, is Burgess, 1991. It also means, as we'll look at in a moment, that diabetics can fall within Dennin's decision in Bratty. So let's have a look at our third case, which is also another epilepsy case. All right, and that's R.V. Sullivan, 1984. In an R.V. Sullivan, the defendant kicked and injured his friendly elderly neighbour during a minor epileptic fit. The fact that this was only temporary did not preclude it from being a defence of insanity. It would not be a defence of automatism, as that required an external factor. This and other decisions regarding epileptic fits demonstrates clearly the legal decision or the definition of insanity being very different from a medical one. All right, so we've got two counts of epilepsy now that we can look at, and one of arteriosclerosis, both of which are included in insanity defences. In this occasion, he's found guilty because he pleads automatism. So he pleads the wrong defence, and therefore the court can only find him guilty. However, it's fair to say, just to put the balance right, that on his conviction, a probation order with medical supervision represented a much better and more advantageous outcome than the order which the court would have been obliged to make if the defence of insanity had been established. So, let's have a look at a very special area of the law, partly because so many people suffer from it, and that's the notion of diabetes. What do we do after Dennin's addition to the what constitutes insanity? What do we do with diabetics? And we need to distinguish between the two different types of diabetes, hyper and hypoglycemia. If diabetics fail to take insulin or to eat or drink too much or get overtired, they can become violent and incapable of control. It is this that means that we have to bring it under the umbrella of insanity. In hypoglycemia, that is a deficiency, I should have really written this down rather than writing it out, in blood sugar levels. I'm going to write that as BS, but you know what I mean, in blood sugar levels. All right, it's a deficiency in blood sugar levels. That means there's too much insulin for blood sugar levels to cope with. This is different from hyperglycemia, which is a deficiency in insulin. All right, and that leads to excess blood sugar levels. And the reason that's important is one will afford a defence of insanity and the other will not. And the way to do that and to distinguish it is to look at the two cases of Quick and Hennessy, one of which is hyperglycemia, one of which is hypoglycemia. If we look at Quick to start with, the appellant is an appeal case. So when I use the word the appellant, I'm referring to Quick himself. The appellant was a charge nurse in a hospital. He attacked one of the patients whilst on duty. The patient was a paraplegic and suffered a fractured nose, black eyes and bruising. The appellant was charged with an assault occasioning ABH under Section 47 of the Offences Against the Person Act 1861. The appellant sought to raise the defence of automatism as that at the time of the attack he was hyperglycemic and that he had taken too much insulin and eaten very little on the day in question. In addition to that, he had consumed alcohol before the attack. The trial judge ruled that this gave rise to automatism, not insanity. So hypo, automatism, not insanity. The defendant then changed his plea to guilty and appealed. In fact, the appeal was allowed and the conviction was quashed. His hypoglycemia was caused not by his diabetes, but by the external factor of insulin. Now, we compare that with Hennessy, and in Hennessy, the defendant was charged with taking a motor car without authority and driving whilst disqualified. He claimed that he was suffering from hyperglycemia. That's high blood sugar caused by diabetes, we know. And he says that he had not taken any insulin to stabilise his metabolism, nor had he eaten properly for days, and as a result was acting unconsciously. He pleaded automatism, but the judge said that he would be only prepared to direct the jury on insanity. So again, we've got two defendants using the wrong, or pleading the wrong defence. The Court of Appeal, in confirming the correctness of the trial judge's ruling, held that the defendant's loss of awareness had not resulted from the operation of external factors upon his body, such as the injection of insulin, as in Quick, but instead had resulted from an inherent physical defect, that is diabetes. The hyperglycemia suffered by diabetics, which was not corrected by insulin, was to be regarded as a disease of the body which affected the mind for the purposes of the McNaughton rules. So in short, hypoglycemia, takes too much insulin. So it takes too much insulin, reduces blood sugar, caused by an outside source, the take-in, the injection, caused by an outside source, and that means automatism because it's external. Hyperglycemia, on the other hand, where you forget to take insulin, reduces blood sugar, gives you high, it's my fault, isn't it? High blood sugar, arises from diabetes itself, so it comes from the disease itself, and that's classed as insanity because it's internal. Not autonomic because it's external. All right, so hypoglycemia classed as automatism and is external. Hyperglycemia is insanity because it's internal.